Hey everybody, it's estate planning attorney Paul Rabelais. Been a little absent on live streams for the last couple of weeks, so it's good to be back here on a Friday evening. Hey Larry, this is I've got a lot to cover. I've been involved in hundreds of probate, particularly the ones in my state where I'm licensed, Louisiana. Oh, by the way, Larry, I've got a state-specific live stream for California coming next Wednesday for all you people who are watching live. If you're from California, got a state-specific live stream. We're going to be dealing with California estate planning specifically, so you can look forward to that. I've done several live streams for various states. Got one coming up on Monday for North Carolina. I know I've done Illinois, South Carolina, a few others I don't even remember. So they're all on the channel. So feel free to check those out. And so got a lot to do with 50 states in our great country. It's going to keep me busy. But generally, probate, a lot of the concepts are similar from state to state. On the other hand, they're all different. Every time I do one of these state-specific live streams, talking to estate lawyers from different states, one of the topics we always talk about is, okay, how is your state's probate system unique? And really, everyone is. Some require court appearances, some don't. Some require automatic delays so that creditors can collect what they are owed from the estate. So there's lots of different procedures. I'm going to focus in on the Louisiana, actually what we call it in Louisiana, because we're different. We call it a succession here in Louisiana. All of the other 49 states call it probate. It's that process of when somebody dies and they've got some assets in their name, those assets become frozen. And so now we have to get the courts involved because judges have to sign orders ordering that those assets, which are frozen, I'll talk more about that later, get transferred to the appropriate heirs. That's all under a kind of a court supervised process with attorney involvement. So a lot to cover. Let's jump right in. So welcome, Larry. By the way, if you've take a little informal poll here. If you've ever been involved in a probate, there's a lot of lawyers out there on and other people out there on the internet, on social media saying probate's a nightmare. Other people, for whatever reason, probate's a piece of cake. So I want to use this time to, if you've ever been involved in a probate, just kind of maybe share what state it was in and what was your experience. And it's okay if you write, hey, it wasn't that bad. It took a couple of months to get done, but we had to sign some paperwork and no big deal. Others of you might say it was a nightmare, and you might give us the reason why it was a nightmare. So love to hear your views on that. If you're watching a recording of this, just kind of throw that information in the comments so we can all benefit from it. Okay. The Louisiana Succession from start to finish. Got 10 parts to this presentation. Number one, I want to describe a fact pattern. I kind of feel like we need to apply a circumstance where somebody died and they had some assets and they had some kids. I'll give you a hypothetical example. Number two is really an important step of determining the need of whether a probate is even necessary or a succession. Number three, meeting with all of the succession participants. Number four, getting the administrator appointed or the executor confirmed. Number five, opening estate accounts. Number six, selling assets and paying debts. Number seven, the detailed descriptive list. Number eight, taxes. Number nine, the petition for possession and judgment of possession. And number 10, transfer assets, because every state does have their own unique terms. And again, I'll be talking mainly about Louisiana's terms, but other states will have a similar process. Okay, so let's jump right in. Good to see you, E. Beatty, got live. So good. Larry said his parents had a living trust, so no problem. Fortunately, I didn't have to deal with probate. Okay, that's the kind of feedback I'm looking for. Thank you, Larry. All right, so let's start with part one of our 10 parts here. Just an example, kind of a hypothetical fact pattern, because I feel like I want to apply what I'm going to say to a hypothetical real life story. So let's say Frederick died. Let's say he wasn't married. Maybe his wife died years ago. Maybe he got divorced years ago. But he's not married when he died, and he had 3 kids. And so the assets that he had were, he had the typical assets, and he had done okay for himself and worked hard and had some assets. So he had a home, and he had some bank accounts. Just ordinary people have a home. They have bank accounts, probably a checking account and a savings account. In addition to his bank accounts, let's say he had a brokerage account. So at an investment company like a Schwab or a Fidelity or a Vanguard or Edward Jones or JP Morgan Chase or any of those investment companies, he had, or LPL, he had a brokerage account. Now, in a minute, we'll talk about how he had an IRA, which is different from what I call a brokerage account, but he had a brokerage account. And let's say the only kind of unusual asset Frederick had was an LLC. Let's say he either owned some rental property in LLC or he had a business on the side that he ran through an LLC, but he did own an LLC when he died. He also owned a vehicle. And he owned, like I mentioned a moment ago, he owned an IRA. Let's say he had some life insurance, and let's say he had an annuity. That was a mouthful. And Frederick had a will, and Frederick left 3 children. And let's just keep that will simple. His will said a lot of things, but let's say his will said, I leave my estate to my 3 children equally. So he had that. And also in his will, just like in every will, he named his executor. Other states call it personal representative or executor. Louisiana, we call it executor. He named his son Jason. Remember, he had 3 children and left his estate to his 3 children equally, but he named his son Jason as what we call in Louisiana the independent executor. More on that later. And then as far as the values of everything that Frederick owned when he died, that's an important issue. But let's say he owned, the total of everything was less than $125,000. That's where sometimes what's called a small succession affidavit can replace a succession or probate. But let's also say he owned, it was over, I don't know what I said. It was what he owned, the gross value of everything was over $125,000. So that eliminates the possibility that a small succession affidavit could take care of this. And if you add up the value of everything that he had, it was fair market value was less than the $13.61 million that would require a federal estate tax return to be filed. So add it all up, might have been a couple of $1 million or so, but somewhere greater than $125,000 and less than $13.61 million. Other than that, it really doesn't matter if the total value is $1 million or $2 million or $5 million or $8 million. Louisiana has no state inheritance tax or state estate tax. By the way, if you're old and you had a relative pass away 25 years ago, you may have recalled that you did have to take care of some Louisiana inheritance tax, but that all went away in the year 2004. We don't have it anymore. All right, so that's the basic circumstances. And now what I want to do, and look, keep contributing to the chat. 1, ask your questions, your comments, share your experiences. Speaking of experiences, have you been involved in a probate? And if so, was it easy and why it was easy, or was it difficult and why it was difficult? And we'll check back on the chat after I finish going through the material that I want to go through. Okay, so number 2 of 10 parts here is, first thing you got to do is you got to determine whether there's a need for a probate or a succession. It's just my opinion. I have no facts to back it up, but I think fewer and fewer probates are required these days because state legislatures have created legislation allowing more assets to be transferred outside of probate. Let me give you a couple of examples. The ones that have been around forever are things like life insurance and IRAs. People have beneficiaries designated on those contracts. And so if you have a life insurance policy and you named beneficiaries and you pass away, those beneficiaries of your life insurance, they just get a death certificate. They produce that to the life insurance company. Life insurance company checks everything out. And if everything checks out fine, they just start writing checks to the beneficiaries. No lawyers are needed. No probate is needed. No courts are needed. Sometimes you'll get a life insurance policy running through an estate, either because maybe there was no beneficiary and the policy requires the proceeds to be payable to the estate of the insured. That happens sometimes. Some people actually, not very often, but some people name their estate as the beneficiary of their life insurance. So that does require it go through the probate process. Sometimes people own life insurance policies on the lives of another, where another person is the insured. Sometimes when the owner dies, the ownership of that life insurance policy has to go through probate to transfer ownership to the appropriate heirs. So sometimes in probate or in a succession, we have to deal with life insurance. But generally speaking, IRAs, life insurance, you've got beneficiaries, all those are what we call non-probate assets. But now, in fact, in Louisiana, it gets really confusing because some banks permit their account holders to set up payable on death accounts, POD as they're called. Louisiana has some odd rules when it comes to banking and POD, payable on death designations. Basically, Louisiana's POD designation, POD law, the only thing it does is it relieves the banks from liability for paying the funds to the POD beneficiaries. And usually that's not a problem if the POD beneficiaries are the same people who are designated in the will. So if Frederick has a will, says, I leave my estate to my 3 children, and he also sets up at the bank his POD designations on his bank checking and bank savings accounts, and he designates his 3 children as the POD beneficiaries, usually no problem. The children will go get those funds using the POD designation and using Frederick's death certificate, and they'll get those funds outside of probate. It can get really tricky, though, if Frederick's will says, I leave my estate to my 3 children, but on his POD designation, he just named, let's say, his son Jason as the only POD beneficiary. That's when it gets tricky, because I think those other 2 children can come back in because of Louisiana's unique POD rules and say, wait a second, that's part of our dad's estate, and that should be divided equally 3 ways, even though dad had named Jason as the only POD beneficiary. So it's tricky. I know, for example, that, and look, if you're from Edward Jones and you want to correct me on this, but I don't think I'm going to be corrected here, as far as TOD, transfer on death designations, I work a lot with all of the different brokerage firms. I believe Edward Jones, maybe rightfully so, doesn't permit its customers, its Louisiana customers, to make a TOD, transfer on death designation. Same problem. It doesn't transfer the ownership of the assets at death. It just relieves the brokerage firm from liability for paying out the assets to the TOD beneficiary. So you're going to find some brokerage firms not allowing Louisiana residents to make TOD designations, but and some of the national companies do. But my point here is legislatures are creating laws to enable more and more assets to pass outside of probate, sometimes making probates unnecessary when somebody dies. I'll give you the practical example. Let's say Frederick dies and his only assets are his IRA, $600,000 IRA, but he named his 3 kids as the beneficiaries. No probate needed for that. He had a $200,000 life insurance policy, named his 3 kids as beneficiaries. No probate needed for that. He had $100,000 in his bank account, and maybe he made a POD designation to the 3 kids and they were able to get it outside of probate. Or maybe he did the hack that a lot of people use. He added his son Jason as having signature authority on dad's bank accounts, so that when dad died, the bank permitted Jason to continue to transact the account. It wasn't frozen. So Jason could go close that account, divide the money up among the heirs. No court orders needed for that. Maybe even if he had a home, he may have put that in a trust before he died. Some people in Louisiana, crazy words here, will give their home to their children during their lifetime, but reserve the usufruct of their home in order to preserve the homestead exemption. But by giving their home to their children while they're alive, making their children what Louisiana calls the naked owners, we don't see that in any other state. Then again, when dad dies, there's no probate needed. The children go from being naked owners to full owners of the property without needing to go through a probate. So, you know, there's a lot of That's the first step, is just determining whether there's a need. Sometimes people die and they have very little in their name. Maybe they don't even have any real estate. Maybe they have a bank account. We do in Louisiana have this small succession affidavit procedure. It applies when someone doesn't have a will. I think the reason the small succession affidavit procedure applies only when someone doesn't have a will is because, well, if they had a will, then we've got to get a judge involved to review the will and declare that the will is valid, even if somebody has less than $125,000. So again, along this line of determining whether a succession is even necessary, sometimes it's not because the estate is small, under $125,000, and there's no will, and we can transfer the assets to the appropriate heirs using this small succession affidavit procedure instead of the full-blown court-supervised succession procedure. So if either that applies, or just if the family has access to all the assets, like I said, assets were things like IRAs, life insurance, bank accounts that they had access to, or if the person who died had created a revocable living trust. I have these conversations all the time with survivors who they've never been through it before. So we have these Zoom calls with survivors, and they're like, Paul, we need to do my dad's probate. He had a living trust. We need to do his probate. And I'm like, okay, well, let's take a look at the assets and see if we really need to do a succession or a probate. So if as long as those assets that dad had were either titled in the name of the trust or they have beneficiaries, that succession isn't going to be necessary. So the first, here we are, number 2 of part 10 is just determining whether there's a need to do a succession. Sometimes there isn't. Number 3, probably the most important part of this whole estate settlement process, is the meeting with all of the estate participants. I've led hundreds, maybe thousands of these meetings, and sometimes they're not done. And when they're not done, the likelihood of there being problems in the estate settlement goes sky high. So here's where the rubber meets the road. It's early in the process. Frederick died. Let's say he died 2 weeks ago. And, they had the funeral a week later, and now the conversation's getting around to, did Frederick have a will? What did the will say? What did Frederick own when he died? All the family members start maybe wondering or asking some questions. That is a great time before you get into it too heavily. And this isn't just a Louisiana thing. This is an all 50 states thing. Early in the process, having a meeting with all of the participants. I love Zoom because oftentimes Frederick or dad will die and children are scattered around the country. And so it really allows for a smooth transition if all of those participants can be a part of a really healthy, transparent discussion early in the process, as opposed to waiting until somebody's mad or somebody doesn't trust someone. So that meeting allows, all the participants involved, and by participants, probably the most important ones are the heirs. Oftentimes the executor is one of the heirs, but that executor would be part of that conversation. Sometimes things are left in trust so that those trustees can be part of the conversation. So anyone involved, sometimes Frederick may owe somebody a lot of money, a creditor of the succession. Doesn't happen often, but sometimes those creditors are part of the meeting, but essentially all of the heirs. So it's, if dad died and he had 3 kids, those 3 kids are on a Zoom call with me when I'm involved in it. All right, so the idea behind that meeting is clarify the roles and responsibilities, address any concerns, and establish open lines of communication. Addressing any concerns before somebody's mad is much easier than addressing concerns after somebody gets mad, gets frustrated, thinks it's going too slowly, suspects someone is mishandling the money. So you want to address those concerns in the early stages while everybody's, nobody's questioning someone else's action. So here's what goes on in that meeting, and I'll tell people, so here's what we're going to do, sorry for your loss. And I'll have, the three kids on a Zoom meeting, and I'll say, here's what we're going to do. I want to go through the relevant provisions of the will. I want to talk about what assets and debts are there, talk about perhaps a timeline, and talk about all the steps that need to take place to go from where we are now to having this thing completely resolved. And oftentimes at the beginning of that meeting, I'll say, look, hey, three of you, I won't say it like that, hey, three of you, but I'll say, look, do any of you have any concerns at all about any issues related to getting your father's estate settled? Because if we know what those are early in the process, we can identify them, we can address them, they can be addressed early on, and if resolved, we move on and things go quickly and easily. So that's the key with that meeting. And sometimes, who knows what somebody will say when I say, does anybody have any concerns that you want to make sure get addressed as we create this overall plan from getting things from the starting point all the way to the finish line? Might hear, one of the children say, well, my father, Frederick, who just passed away, he promised his truck to my son. That statement may come out of left field from one of the children. And so again, while everybody's getting along, and while maybe the family will have a discussion about that, and maybe the other two children will agree, and maybe they heard Dad say that. Now, Dad saying it has no legal effect because Dad's will says I leave everything to my three children equally. But when something like that is brought up early in the process, if everybody's on the same page, I might have to explain, so you all are comfortable with your dad's truck going to, your dad's grandson. And they might say, Dad did always say that, even though it wasn't in the documents. Then, we'll have a conversation about how, well, the truck's going to go to the three kids, and then the three kids can donate their ownership interest in the truck to that grandson. So again, those are the kinds of things where, hey, does anybody have any concerns about this? And, somebody might say, well, I loaned Dad some money, and I loaned him $25,000. We usually don't see the children loaning the parents money. It's usually the other way around. Hey, Dad loaned me $25,000, and then we got to, have a conversation about that. Where is it an actual debt? Was it a gift? Was it a debt? Does that child now get $25,000 less because that loan is factored in? So all those things that are on people's mind, big or small, it's great if they can be addressed in a meeting before we dig into the nuts and bolts of the succession or probate. I keep saying succession or probate because this is the Louisiana version of it. I'm going to call it succession. When I say succession, if you're in a state outside of Louisiana, you can just replace that succession word with probate. All right. So far, so in that meeting, it's like we review the will provisions. That's why I like Zoom. I can pop that will up on the screen, and because sometimes people think a will says something, but it really doesn't. It happens all the time. Yeah, Dad did this, but no, let's look at his will. He really didn't do that. So we can pop that will up on the screen. Here's who Dad left the assets to. And I know earlier I said Frederick's will left everything to the three children equally and named one son, Jason, as the executor. But maybe I can point out here's where Dad left $10,000 to his church. He left $15,000 to each of his grandchildren if he would have done that. So, we get that kind of buy-in of what Dad did, and the fact that Dad named Jason as the executor. Sometimes maybe Dad's will said, I named Mom. He would have put her name as the executor and named Jason as the alternate executor. We put all that. Mom's deceased. So we talk about how Jason is entitled to be the executor now. More on that later. So we go over the will provisions. We talk about the assets. A lot of times heirs mistakenly assume that the person who died had lots more in assets than they really did. Oh, Dad told me 2 years ago that he had, $6 million of assets, where in reality it's only like, $1.2 million. So now's the time, early in the process. Hey, here's dad's bank account statements. Put them up on the screen. Here's his checking. Here's his savings. Here's his brokerage account. Here's his IRA. His house is worth more or less something like $400,000. We don't know. Let's just hypothetically put a number on it. Here's what dad owed. Here's his last credit card bill. He owes $17,000 to American Express. He owes $8,000 to Visa. So here's all the assets and the debts. Does anybody have any questions about what dad owned and what dad owed? So we're getting all that discussed up front. And again, it avoids surprises down the road and gets everybody on the same page working toward a common goal. So that collaborative approach where at the end of the meeting, it's like, okay, here's the 9 steps that we have to go through from where we are now to getting everything settled and everybody receiving their inheritance and all the loose ends being taken care of. And that just, it does foster transparency. It builds trust. It streamlines the succession process, leading to a much more orderly administration of the estate. So where it kind of, my stomach turns is when I get the call a year and a half into it and some heir, I get on a Zoom call with some heir and they're like, I've never seen the will. Apparently my brother's the executor and I haven't talked to him since the day dad died. I have no idea what they're doing with the money. And again, that just, it's awful. So, and those are the kinds of successions that never end because they can't end until everybody's in agreement and signs off on all of the court paperwork. And when you have one person who is either, there's some distrust there or lack of communication. Sometimes you have one or more participants who don't really want to be cooperative. They kind of fear signing off on things until they get more information, and it goes on for years. Okay, but let's assume in Frederick's case with his 3 children, Frederick died. Son Jason's the executor. Will says leave everything to the 3 children equally. Went through all the assets. Probably in that meeting had some discussion. Hey, what are the plans with the home? Maybe dad had a $400,000 home and maybe maybe the kids have already discussed it. Maybe the kids said, let's sell the home. And so, but there's a conversation about the home. What do you want to do with these various positions in dad's brokerage account? Sometimes dad will own stock that the family may be emotionally connected with. So maybe in that early meeting, it's decided that, hey, let's not sell that stock. Once the succession is moving toward completion, instead of selling that stock from the estate, let's just get that stock. He owned 3,000 shares. Let's just, when it's time to distribute everything, let's just make sure each child gets their 1,000 shares. Once they get it, they can do whatever they want to with it. I was having a call this week, and it was there was a daughter that was one of the heirs, and there was some, between the heirs, there was some not real good communication, to say it best, and so. The parent owned some stock, and the stock was going to be divided up among the children. And one of the children said, well, I don't want to be in business with my sibling who I never talked to. She didn't say it that way. But I was like, no, just dividing up shares in publicly traded companies does not mean you're in business with your siblings. You own your shares and you can do whatever you want to with, and your sibling owns their shares that they can do whatever they want to with, but you're not in business with your sibling when you're dividing up shares in a publicly traded company. But let's say in Frederick's case, the meeting went well. Everybody agreed on kind of the relevant terms of the will and what that meant. There was full disclosure of all of the assets. We talked about the steps involved, which is what we're going to talk about next. And everybody was like, great. Maybe a timeline was discussed. Hey, this might take 6 months. It might take a year and a half, depending upon the complexity and the state and what's involved in getting everything settled. So, it's really tough to predict a timeline because there's so many moving parts. You're dealing with courts, you're dealing with brokerage firms and the lawyers of the brokerage firms, lawyers of financial institutions. You're often waiting on various assets to be sold during the probate process. It may take 2 months to sell a home. It may take 2 years to sell a home, not to mention if the estate owned a business or something like that. So it's hard to predict accurately what a timeline for the probate is, but maybe you gave it a shot. All right, so everybody's feeling pretty good about that meeting. They got a plan. There's some transparency and some trust built, so that's great. All right, next steps. Next steps is what I call, depending on your circumstances, either getting an administrator appointed or getting an executor confirmed. So in our case, Frederick, he had a will, and in his will, he named his son Jason as the executor. So in that case, the next step is getting Jason confirmed as the executor. However, let's change the facts up a little bit. Let's say Frederick didn't have a will. Now an administrator has to be appointed. Those roles are similar in their responsibilities. Just the title is different. If you have a will, you name your executor. If you don't have a will, then the court appoints an administrator. Again, the administrator / executor's job is to make sure all the procedures are followed and kind of see that the whole process is followed correctly. But in our case, Frederick, he had a will, named Jason as the executor. Got to have that will to get started, because in order to get started, you have to file that original will at the courthouse with some other pleadings that the lawyer prepares. Oh, by the way, I've talked, again, having these live streams with all of these lawyers in different states. I can't remember what state it was, but one lawyer was like, yeah, we have the probate forms in our state, and it's possible for people to handle a probate without lawyer involvement. I would say in Louisiana, that's really difficult because we just don't have standard court forms for a succession. So all of these pleadings are like created from scratch by the attorney, and it's all these procedural rules that have to be followed. So I saw it once where a retired engineer, and if you're an engineer or if you know an engineer, you'll know what I'm talking about. Very, very much attention to detail, very insistent on doing everything himself. Also insistent on, as he did it himself, he wanted to run it by me to get my approval, which was more difficult than me just doing it myself. So anyway, in Louisiana, I'm just going to make a blanket statement. You need a lawyer to guide the heirs through the court process. All right, now we need the original will to get an executor confirmed. We'll talk about why an executor needs to be confirmed here in a minute, but we need to have that original will. If you can't locate the original will, and by original will, I don't mean first will, I actually mean the last will, and that's confusing. The last original will. By original, I mean the one that Frederick actually signed. It was probably notarized with a notary seal that was raised, and so you can tell it's the original, even though these days our copy machines are so good, and even if Frederick signed it in blue ink, the color copies these days look just like an original. But we have a rule that says if you can't locate the original, if Frederick dies and you can't find the original will, then it's presumed that Frederick destroyed his will with the intent to revoke it. And then if you want to, if everyone believes that he didn't destroy his will with the intent to revoke it, everybody just believes they can't find it. It got lost. He signed his will 20 years ago. We can't find it. You can overcome that presumption that he destroyed his will with the intent to revoke it, but it just means more red tape. So bottom line there, you want to keep your original will in a safe place. Make sure your survivors have access to it. Some people keep it in their home. Some people put it in a safe. Some people put it in a safe deposit box. I think safe deposit boxes are being used less and less these days. But and also in the old days, people used to have their lawyer store their original will. We don't do anything like that. I mean, I can't imagine me at 59 years old storing the will of somebody who signed it when they're 60 and they die when they're 95, 35 years from now. I'm not going to be around to give that family the original will that they gave me 35 years earlier. So I really think it's kind of silly that lawyers and law firms keep those original wills, just because people move around so much and it's hard to keep track of everything. So anyway, got to have the original will. And many people mistakenly believe that, well, we can't start the succession because we don't have the death certificates yet. That's a false assumption. Death certificates are never filed at the court. I don't want to say never. Generally speaking, death certificates are not filed in the succession proceeding, because instead of filing death certificates with the courthouse, two people who knew Frederick, in our case, and probably it's going to be two of his kids, two people who knew Frederick have to sign what's called an affidavit of death, domicile, and heirship. And in that affidavit, it says Frederick died on June 16th. He wasn't married. He had a will. He had 3 children. All of the children are over the age of 23 and they're not forced heirs. And then some other required language that must be in that affidavit of death, domicile, and heirship. Sometimes that third child will say, wait a second, how come I'm not signing one of those affidavits of death, domicile, and heirship? Doesn't have anything to do with what kind of financial interest you're going to inherit. It's just two people who knew the decedent, knew Frederick, have to sign an affidavit. So if it's 2 of the 3 children, it's the third child who isn't one of those who signs the affidavit is not left out in any at all. Okay, so here we are. We're just starting. We've had the meeting. Everybody's good. Where they produce the original will. Lawyer prepares all of the pleadings to get Jason confirmed as the executor. So the lawyer is going to prepare something called a petition to probate. Probate the will really means to get a judge to declare that the will is a valid will. Judge signs a court order. Hey, I've reviewed this will. It meets all of the validity requirements for a will in Louisiana. I'm ordering that the will is valid, and I'm ordering that Jason be confirmed as the executor. So let me go through a little terminology here. We usually don't say executor. We say that informally. We say Jason, we want Jason to be confirmed as the independent executor. A quick summary of the difference between an executor and an independent executor. It's almost a non-issue anymore because this law was changed, I don't know, 20 years ago, more than that maybe. If Jason is just an executor, then virtually every action he takes as an executor, if he needs to sell a vehicle that's part of the estate, if he needs to make some distributions that are part of the estate, if he needs to pay some debts that the estate had, he's got to get a judge to approve all of those actions. But if he's an independent executor, then it's not that there's no succession. There's still a succession and there's still court involvement. But if Jason needs to sell an estate asset, if Jason needs to pay some estate debts, he can take those actions. If he's an independent executor, he can take those actions independent of court approval. So we always want that executor to be an independent executor. How does Jason become an independent executor? Well, because Frederick's will says something like, I name Jason as my executor and I authorize my executor to act as an independent executor. But if the will doesn't say that, and virtually all wills written these days, unless it's almost a mess up, virtually all wills say authorize that executor to be an independent executor. But if it doesn't do that, if it just says I name Jason as the executor and it doesn't say anything about an executor being authorized to act as an independent executor, well, then if all 3 of the heirs agree and sign off on an agreement to allow Jason to be an independent executor, then Jason can be an independent executor and can take those actions, a lot of those actions, without needing court approval. Sidetrack, if Frederick died and he had no will, typically what happens is, I'll tell the 3 of them, hey, it's, really one of you or a judge is going to have to appoint somebody to be the administrator, or even better, if all of you heirs agree, the independent administrator. Usually the 3 kids, unless there's some serious sibling rivalry, will kind of come to an agreement. Okay, let's let Jason do it. Jason's an accountant and Jason lives 3 doors down from our father, and Jason's been taking care of all of our dad's bills and he's been doing a great job. Let's appoint Jason as the independent administrator. And then the 3 of them will sign off on the court paperwork and they'll sign off an agreement allowing Jason to be an independent administrator, even though Frederick had no will. Okay. And then so they all petition the court, and the judge sees that all three heirs have agreed that Jason should be the independent administrator, and the judge will sign the appropriate court orders. Okay. I will say, because every succession is unique, sometimes you can complete a succession without getting an executor confirmed or an administrator appointed. So let's say, for example, Frederick dies, and the only asset that is in his name that's required to go through the probate is his home. And the three kids are like, we don't want to sell the home, at least not for several years. We'll use it as a home when we come into town or whatever. They just don't want to sell it. And that's the only asset. Well, sometimes we can skip the process of getting, even though we had a will naming Jason as the executor, we can skip the process of getting an executor confirmed, because there's really no actions that Jason needs to take as an executor. There's no money to collect. There's no bills to be paid. It's just getting that house transferred or that piece of land transferred. And so sometimes we will handle a succession without an administration. Kind of tricky to do that, because sometimes when you go that route and you're in the middle of it, then during the process, you realize, oh, geez, he just got a check payable to Frederick's estate it's a refund from the assisted living facility. And, you wish you would have gotten Jason confirmed as the executor so he could have opened an estate bank account. We'll talk about that in a minute. So I'm just making the point that sometimes you can complete a succession without getting an executor confirmed or an administrator appointed. Okay. So here we are so far. Let's recap. We went through the fact pattern. We determined there is a need for a succession. We had a meeting with all of the participants, reviewed the will, reviewed the assets, got everybody on board, had transparency. We filed all the court paperwork to get Jason appointed or confirmed as the independent executor. The judge signed all of the court orders, probated the will. The will's valid. The judge says Jason is now the executor. Now what do you do? Okay, so now because Jason can't take any action as the executor until a judge signs the appropriate court orders. You might be asking how long that takes. So we got to prepare a bunch of court paperwork. We got to get the heirs to sign off on it. And then we got to follow to the courthouse, and then we got to wait. How long do we have to wait? When it's incredibly fast, a few days. When it's kind of normal, a month or so. When it drags on, it could be a few months of just the step of getting Jason confirmed as the executor. All depends on a lot of different factors, what parish you're in, judges, the employees at the courthouse, any number of things, can cause delay. So anyway, it does happen though, eventually. Sometimes we have to keep calling the judge's office in the courthouse, over and over and over to push the thing along. But sometimes, let's say so, but nonetheless, it happened. Jason's now the executor. What does he do? Well, now Jason's going to have to go around and kind of pool together Frederick's money. And one of the first things we need to do is we need to get an EIN or TIN, employer identification number, or tax identification number for the estate. Because some banks and some financial institutions, they won't do anything until the estate has its own employer identification number or tax identification number. It's the same thing. So anyway, I'm gonna get Jason to sign an SS4 form. It's an IRS form. It's an application for a tax ID number. We can get that number online. Jason now is armed with his what's called letters of independent executorship that the courthouse produces once the judge signs the order confirming that Jason's the executor. Other states might call it letters testamentary, letters of executorship, letters of administration. So we call it letters of independent executorship. So Jason has multiple certified copies of his letters of independent executorship. He has his tax ID number. He now goes to Dad's bank, where Frederick had a checking account and a savings account. Probably to keep it simple, Frederick opens an estate account at that bank. So he'll submit his court orders. He'll submit his tax identification number. The person at the bank will probably tell him, let me scan all that in. We'll get our legal department to review it. Once they approve it, we'll open the estate account. And what the bank will do is they'll move dad's money from his frozen checking and savings account. If he had $30,000 in his checking account and $100,000 in his savings account, once all of the initial stuff gets done and the procedural stuff gets done to take care of this, the bank will close Frederick's checking and savings account and move that $130,000 into an account in the name of Estate of Frederick, Jason as independent executor. Yeah, Jason could, if he wanted to, open up a checking account and a savings account, but if this is a relatively smooth succession, probably no need for the savings account, because the estate checking account is really a temporary account. Ultimately, that money's going to be dispersed to the heirs. But, he could open up a checking account and a savings account. Now, Dad also had a brokerage account that is now frozen. So Jason probably needs to open multiple estate accounts. He opens one at the bank so that he can get checks and write checks to pay estate debts. But then he can't transfer the brokerage account investments, stocks, bonds, mutual funds. He can't transfer that stuff into the bank account that holds cash. So he'll also bring his letters of independent executorship, his tax ID number, to the brokerage firm, and he'll establish an account at the brokerage firm in the name of Estate of Frederick, Jason as independent executor. And now the brokerage firm will move the assets that were held in Frederick's brokerage account into the estate account. Now, what Jason will do with those assets, once they're in the estate brokerage account, maybe that was discussed in the early meeting. Maybe he just holds those assets in the estate brokerage account and then, disperses those. Like I said, if Dad had 3,000 shares of stock in a company, maybe it was agreed to that Jason is ultimately going to distribute 1,000 shares to each of the three. But maybe Frederick had 12 shares of this and 9 shares of that and 3 shares of that. And maybe it was agreed, or maybe Jason would just say, look, I'm going to sell just this miscellaneous stuff. That'll make it easier to distribute cash to the 3 heirs or the proceeds of the sale. So there's some decision making to do on what to do with the estate assets that are in a brokerage account. So now Jason's starting to secure the financial assets. Now let's move on to the next step, selling assets and paying debts. There's no requirement that Jason sell all of the estate assets. You remember that Frederick owned a home, he had a brokerage account, he had an LLC, he had a vehicle. But in most cases, the family gets together and they talk about what's the best thing to do with Dad's home, with his vehicle, with his business. And so let's say the family decides, I think we need to sell Dad's home. We really don't have any use for it. Yeah, we need to clean it up. So we always hear that. And so that home, if it's going to be sold, it will either be sold from the estate. Jason will handle all that. Jason will, if he gets a realtor, he'll go get a realtor and he'll list the property for sale, and he'll negotiate all the terms of the purchase agreement when they find a buyer. Jason will attend the closing. The check at the closing will be payable to Estate of Frederick, and Jason will take that check and deposit it into the estate bank account, probably. So when a house is sold after a parent dies, it's either sold from the estate. In that case, the independent executor can sell it. Or let's say it just doesn't sell for months, or the family decides to hold on to it. Then at the conclusion of the succession, the house, and we'll talk about the process for this in a moment, but the house will simply be transferred to the 3 children. So the 3 children will then become the co-owners, each owning what I call an undivided 1/3 interest in the home. And then if it's sold subsequent to that, then the 3 children would participate in the sale. And if it sells for $450,000, then at the closing, each child will receive their 1/3 or $150,000 as a result of them selling their 1/3 interest in the home. So, and but let's say, Dad's truck needs to be sold. So again, Jason, as the executor, he can go sell it. When he sells it, check gets payable to estate of Frederick. Jason deposits that into the estate account. So there's usually an analysis made by the executor or by all of the heirs when there's a lot of transparency and getting everybody involved as to what assets get sold and what assets don't get sold and simply get distributed to the heirs. Now, Dad may have had some debts. He may have, bills related to his house. He may have some credit card bills. He may have a car loan outstanding. So, decisions need to be made on what to do with that. Oftentimes, if there's cash, Jason will pull that cash into the estate account and pay off those debts. I will say with credit card debts, maybe Jason would say, well, let me contact each of these 3 credit card companies. Sometimes the credit card companies, just to kind of wipe the slate clean, will agree to maybe take less than what is owed in order to get the thing taken care of. So maybe Jason did a little of that, or maybe he just paid the amounts that are due in full. The estate owes it, and so you really can't get around it. If Jason owes Visa 25, if Frederick's estate owes $25,000 on a credit card, then even if all of the assets get distributed to the 3 children, in theory, the credit card company could come back against those 3 children and force them to give back some of their inheritance to pay Dad's debts. So you want to make sure you get all that stuff taken care of, especially if you're the executor, to avoid those difficulties later. Maybe the credit card company will file a claim in the estate, and that way the assets then can't get transferred to the heirs until the estate's claims have been satisfied. So lots of issues involved. Maybe I'll do a live stream just on, debts that are involved in the estate. All that stuff needs to be addressed. And, while you're doing that, look at the will. Sometimes a will say, hey, I leave my house to this person, and I direct that if I do have a mortgage on my house when I pass away, that I direct that the mortgage be paid out of the residuary assets of my estate. So then the estate is on the hook for paying off the mortgage, so that the person inherits the home free and clear of any mortgage, again, if that's what the will directed. So you got to look at all that. Okay, now we're moving on here. We're moving on to what I call step 7 of 10. What I call in Louisiana the detailed descriptive list. You hear a lot of in other states. You hear the talk of creating an inventory. But in Louisiana, it's called the detailed descriptive list. And what it is, it's as of the date that Frederick died. It's a list of all those probate assets, all the bank accounts, the LLC, the brokerage firm account, the vehicle, any debts, credit card debts, any expenses, lawyer fees that are involved in the succession. All that gets listed on what's called the detailed descriptive list. Not only the assets, but also the value of those assets as of the date that Frederick died. So the value is important because that date of death value determines what's the capital gains tax basis for the heirs. So if Dad had a home and it was worth $450,000 when Dad died, that $450,000 value gets put on the detailed descriptive list. That's the capital gains tax basis for the heirs. So when the heirs later sell that property, because the house got that step up in basis to the value on the date that Dad died, when the heirs sell that asset, they'll only pay capital gains tax on what they receive in excess of what it was worth when Dad died. Same rule applies to brokerage firm assets, stocks, bonds, mutual funds that Dad may have owned when he died. They all get that step up in basis. All of the appreciation up until Dad died goes untaxed. That step up in basis is kind of a big deal. Some people think that, let's put a really high number on the detailed descriptive list, and that way the basis will be much higher. Well, the family, the executor, puts the value on the detailed descriptive list. That's not the final determination of basis. The actual determination of basis is what is the actual fair market value of the asset on the date that Frederick died. So just because somebody tried to play around with things and put a higher or lower number on a detailed descriptive list, that's not the ultimate determination. The IRS could question that. Okay, so also all those assets that are listed on the detailed descriptive list, again, as of the date that dad died, that will often determine the executor's fee. Unless dad addressed it otherwise in his will, the executor is entitled to a 2.5% of the gross assets succession fee. So if dad had $1 million of assets, that's a $25,000 executor's fee that Jason's entitled to. Sometimes you'll see the Jasons of the world say, you know what, I'm not going to accept the executor's fee. I'm honored that dad picked me. He left his estate to his 3 children equally. I'm not going to accept an executor's fee off the top. Let's just split everything up 3 ways. That has a little bit of a tax benefit as well, because if Jason takes his $25,000 executor's fee, 2.5% of $1 million, that's earned income to Jason, and he'll have to pay income tax on that $25,000. But if Jason doesn't take the executor's fee and everybody just splits their $1 million, splits the $1 million estate, generally speaking, an inheritance is free of income tax. So Frederick's entire estate goes to his 3 children free of income tax. Kind of an, oh, by the way, if Frederick had a traditional IRA and he named the beneficiaries, then those beneficiaries will have to pay income tax on distributions from their inherited IRA. And under the Secure Act, they'll have 10 years to take it out of their inherited IRA and pay all the income tax on that inherited traditional IRA. Okay. So a lot there on the detailed descriptive list. Again, the IRAs, unless they were payable to the estate, the life insurance, unless it was payable to the estate, don't get listed on the detailed descriptive list, because the IRA and life insurance are non-probate assets. Just those probate assets get listed on the detailed descriptive list. Moving on to taxes. Oftentimes, an estate is required to pay income tax. So there's a couple of income tax matters here. Perhaps Frederick's final individual, let's say, Frederick died on June 30th of 2024. Well, Frederick is going to have to file a final income tax return. And so that can't really be filed until 2025, when the 2024 income tax returns come out. So Frederick will have a final income tax return. And then if Frederick's estate is open for a while, and his brokerage account produces some dividends, or his estate produces some income, then perhaps his estate will also have to file an income tax return for that income that the estate earned subsequent to the date that Frederick died. So Jason's going to have some income tax issues to deal with. We already talked about earlier, there's no estate tax issues, because when you add up the value of Frederick's estate, not just his probate estate, but for federal estate tax purposes, you also lump in the IRAs, the life insurance policies that Jason owned and was the insured on when he died. You throw all that in for purposes of federal estate tax calculation. But even if you do that in Frederick's case, it was well under the $13.61 million threshold for 2024. Only if someone has gross estate in excess of $13.61 million does it trigger this estate tax return filing requirement that may trigger a 40% federal estate tax on those net estate assets that exceed the $13.61 million figure. But in this case, doesn't apply. There is no inheritance tax. I mentioned that earlier, because Louisiana doesn't have an inheritance tax. Louisiana doesn't have a state estate tax. There's a handful of states that do. So, let's see, Washington was dealing with that the other day. That tax can be as high as 20% at the state level. So, you got to be aware if your state has some type of state estate tax or state inheritance tax. And again, there's some capital gains tax issues. Whether an asset is sold while it's in the estate, or whether it's sold by the heirs because the asset gets distributed out of the estate to the heirs. When an estate asset gets sold, you have to address the capital gains tax consequences. Let's say dad owned a home worth $450,000 when he died. And let's say he bought it 20 years ago for $100,000. Well, the beautiful thing is that $350,000 of gain, untaxed, capital gain. When he died, it was worth $450,000. That established the new capital gains tax basis. Let's say the kids hold on to it for 3 or 4 years, and they sell it 3 or 4 years later for $550,000. Well, there's $100,000 of capital gain, and each child is going to have to report their share of the capital gain on their income tax return. Because that represents the appreciation that took place since dad died. So be aware of that. All right, we're starting to wind up here. So had the family meeting, all good, reviewed the will, reviewed the assets, got Jason confirmed as the executor. Jason pulled all the cash into an estate bank account. Jason pulled all the brokerage account assets into an estate brokerage account. Jason sold the car payable to the estate, dumped that money in the estate account. Jason took care of Frederick's final income tax return and perhaps even had to file an income tax return on behalf of the estate. Jason dealt with all the credit cards and other debts. Family got together, decided what to keep, what to sell. Jason sold what he needed to sell. Now there's a bunch of assets still in the estate, and there's some cash in the estate. So now it's time to detailed descriptive list has been prepared, all the assets, all the debts. Now probably it's time to, hey, let's work toward ending this thing. And so lawyers will prepare what's called a petition for possession and a judgment of possession. Petition for possession it's basically a petition asking a judge to order that all the remaining estate assets get transferred to the three heirs. It kind of lays out the whole story. Hey, Frederick died on June whatever, 2023, let's call it. Jason got confirmed as the executor. The will is part of the probate record that shows Jason's estate goes to the three children. Jason as the Frederick's estate goes to the three children. Jason as the executor has paid off all the debts. The estate is now free from debt. And now the three children are joining, all signing off on a petition asking a judge to sign what's called a judgment of possession, ordering that all the remaining estate assets be transferred to the three children equally, and relieving Jason from his job as executor because he's basically finished. So the reason for the early meeting was to get that buy-in from everybody, because you can't do this final step of getting a judge to order all of the assets to be dispersed to the three heirs unless all of the three heirs participate and sign off on this petition. If you didn't have good communication throughout the process and there started to be some lack of trust and some, hey, what's he doing with the money? Hey, Jason won't even return my phone calls. I send him texts, I send him emails, I get nothing. What's he doing with the money? He sold dad's car. I don't know what he did with the money. But if you have that transparency, then you're likely to get that buy-in from everybody on the back end when it's time to go to court and ask a judge to approve everything and approve the distribution of assets to the heirs. So let's say the judge signs that order, and let's say the house never sold. So that judgment of possession orders that the house and all the other assets that are listed in the judgment, but the judgment is a court order that a judge signs ordering that the house be transferred to the three children. And so technically the way the house gets transferred, once the judge signs that order gets recorded in what's called the conveyance records of the parish where the home is located. That's what transfers the home from dad's name into the three children's names. Now the three children can keep it or sell it, or maybe one of them buys the other two out, or they can do whatever they want to do with it as long as they all agree. And then there'll be on that judgment of possession, it will order that the brokerage firm transfer assets to the three children. So the three children will likely have to set up their own brokerage account at the brokerage firm so that the assets can be transferred from the estate account into each child's brokerage firm account. Once the investments go into the child's brokerage firm account, they can keep it there, they can move it, they can sell it, they can do whatever they want to. A lot of children mistakenly believe that, okay, my dad had all these investments at Schwab. Now all these investments are in an estate account at Schwab. I've got to open up an account at Schwab, I'm told, and I've got my investments at this other place. I can't believe I've got to have a Schwab account. Well, you don't. You have to have a temporary Schwab account. And look, no disrespect to Schwab, but once a child does transfer to get the investments transferred from the estate Schwab investment account to their individual Schwab investment account, then they can move that account or do whatever they want to with it, move it to any other brokerage firm that they want to, that they work with. All right. So again, if dad owned an LLC, the judgment of possession is going to order that dad's membership interest, which is what an ownership interest in an LLC is called. The judgment will order that the LLC membership interest be transferred to the children. So if dad owned 100% of the LLC, this judgment is going to order that each child now owns 33.33% of the LLC. So you get all those assets transferred. Maybe the executor holds back maybe $10,000 or $20,000, maybe $30,000, because maybe all of the assets are being distributed, but Jason can't file that final estate income tax return until next year when it's due in April. And so he wants to hold back some funds to cover that expense. And that starts to wind up the whole succession proceeding. Again, everyone is different. Tried to give you kind of a common scenario where somebody died with kids and they had a variety of different assets, but that's the way it goes. Let's move over, see what we've got here. Okay, so Larry, good. Yeah, Chelsea. Yeah, good to see you, Chelsea. Seen you around a few times on our live streams. Zoila, I think I've seen that name. You're welcome. And I've seen Hong. Thanks for sharing these issues. And good, fantastic. And I like your emojis. You got some really, really cool ones there. Some of the best I've seen on my channel. So good job there. Ling says, been listening to you for about a week, head spinning. I have one growing, one single. Which state is better, SEPA living? Well, it's really most appropriate to set up your living trust in the state where you are domiciled. So our law firm has, attorneys licensed in Louisiana and Texas. So, but if you live in Texas and you're going to continue living in Texas, probably best you create a Texas trust. If you move to another state later, it's okay. You can keep your same trust. Really, what I like to say is, if you move to Minnesota after creating a Texas trust, it's just that if you die in Minnesota and there's some dispute as to how your trust should be interpreted, for example, that might have to get resolved in a Texas court. For most families, there isn't a dispute as to what the trust terms mean. So it's okay to move to another state, even though if you formed a state in another trust. If Chelsea, if there's no will for someone who had several children and a spouse previously, is there a presumption that the decedent intended to divide his estate equally among his children? Well, it's not only a presumption, Chelsea, but the law mandates that if an unmarried person dies with no will, Louisiana law mandates that their estate be divided equally among their children. So it's not even, it's stronger than a presumption. It's a mandate. Now, if the person did have a will and they left it all to one child or left it all to whoever, then these intestate laws don't apply. Intestate laws means the laws that apply when someone dies without a will. If a property title has two owners, 50-50 co-owner, create a living trust and transfer the house title by himself without the other knowledge. Yes. So if Jack and Jill are siblings and they each own 50% of the parent's property or home, and Jack wants to transfer his 50% interest in the home to Jack's living trust, he can do that without Jill's involvement, participation. Now, the transfer may be recorded in the public record, so maybe Jill could see it. But what Jack does with his 50% has nothing to do with Jill being a 50% owner also. All right, see you. Thank you for that. BB, need help. Father died 2023. Sister, anything about farm ground that should have been in a trust? So again, that's a kind of a common example. And, if someone is an executor, they are required, oftentimes upon request, to release information to the heirs. And similar rules, if property is in a trust, then the trustee has certain obligations to provide information to the beneficiaries of the trust. All right, is the step up as of date of death or when the heirs take title of the asset? Good question, Chelsea. It is absolutely 100% date of death. So if dad dies, he had a house worth $450,000, and the house ultimately does not get transferred to the heirs until a year and a half later when the property is worth $550,000. the basis in that property is $450,000, the value on the date of death. I'll mention this exception. It rarely, if ever, applies if dad had a large estate and he owed estate tax, which means he would have had to have had an estate that exceeded $13.61 million. And if the alternate valuation date was selected, and all of the assets were valued as of 6 months after dad died, then that's the new capital gains tax basis. But only if all of those things happened, which rarely happen, because one of the things that has to happen to use the 6 months after death alternate valuation date is there has to be estate tax due. Okay, permanent mobile home. What's the best way to heir it to your kids? I'd have a lot of questions there. Do you want to leave it to all of your kids? Do you want to leave it to one of your children? If you have 3 kids and you want it to be treated like any other asset, just left to the 3 kids, then I don't even know if you need to specify or carve that out. It just goes to the 3 kids. They'll deal with it, and they might sell it, split the money. Or if you want it to go to one person in particular, you're going to have to document that, and that person would be entitled to it. All right, Larry. All right, California. See you Wednesday. Probably see you before then, because I've got a couple of other ones coming up as well. So, all right. So again, what I'm doing here, a lot of the stuff I did in the past was just kind of nationally oriented, but now I'm trending toward trying to get more state specific and get more a little bit nichey. So some of these things, live streams that I give, they may not be applicable to you. Like this one tonight, it was really, what's the Louisiana Succession all about? But I've got a lot of, as you know, I have a lot of videos on my channel, and a lot of them are just kind of general information. And so a little combination of both there. All right. Thanks, everybody. We'll see you next time.